How many days do you have to contest a trust? Typically, if you're a beneficiary of a revocable living trust or an heir of a trustor or grantor, the person who created the trust, you have a minimum of 120 days to file your contest petition in the appropriate court, at least in California. The 120-day time period may seem excessively short, but statutes of limitation are designed to bring finality to cases. Here, the abbreviated timeline is to allow trust estates to be settled more quickly so people can move on with their lives. To take advantage of the abbreviated 120-day filing deadline, however, the successor trustee of the trust must send the required notice mandated by California Probate Code within 60 days, and it must include the mandatory notice and a copy of the trust documents. If it's not issued within 60 days, then the shortened filing deadline doesn't apply. Also, the deadline will not apply if the notice fails to include all the required language. Finally, if the notice does not include the trust documents, then the 120-day filing deadline can be extended up to an additional 60 days if the documents are provided later within those original 120 days, for a total of 180 days. It's all very confusing. Have questions? Schedule a free consultation online at our website, rmolawyers.com. Are there exceptions to the 120-day rule? If the notice is untimely or incomplete, then the standard statute of limitations apply to your claims, which usually are 3 or 4 years. However, if no documents are provided with the notice or forthcoming thereafter, then you'll need to seek court intervention to obtain a copy of the documents or risk waiving your ability to contest. The 60-day, 120-day, 180-day, or more deadline, and what documents you're entitled to and when can be confusing, and you'll be well served to consult with a probate litigation attorney to determine the actual deadline to file your contest to make sure you don't waive your claims. Can you challenge a trust after death? Yes, of course. Probate courts are built specifically to handle trust challenges after a decedent passes, and trust litigation attorneys routinely handle post-death trust contests and challenges. If you believe you've discovered an impropriety with a trust or a trust amendment after a loved one passes, you'd be best served to consult a trust litigation attorney to go over your case sooner rather than later to avoid missing any important deadlines, including the 120-day deadline we just discussed. Can a trust be overturned? While the vast majority of contested trusts and trust amendments are going to withstand challenge with the right facts carefully procured and presented to support winning legal arguments, it is very possible to overturn a trust or a trust amendment. This is why you should consult a trust litigation attorney as soon as you have facts that lend themselves to a challenge. If you successfully petition a probate court to overturn a trust or a trust amendment, usually the court will reinstate the grantor's most recent prior valid trust document or amendment. In the case of a successful challenge to a trust amendment, the trustee then would distribute assets based on the trust terms that existed before the amendment even happened. However, if you have an entire will and trust overturned and there are no earlier documents, the estate will be split based on the state's intestacy laws. In that case, only family heirs will receive a share based on their degree of kinship to the grantor. What rights do I have as a beneficiary of a trust? Trust beneficiaries have many rights, including the right to be reasonably informed about the trust, its assets, liabilities, administration, and expenses, as well as when your share of the trust is going to be distributed to you. As a trust beneficiary, you have standing to challenge a trust or a trust amendment, and you also have the right as an interested party in the trust to challenge a trustee's actions in court to ensure they're discharging the fiduciary duties that they owe to you. If you believe that a trustee is not abiding by the terms of a trust or is refusing to provide transparency, including accounting for assets and expenses, you can seek their suspension or removal. Whether a court is going to be willing to suspend or remove the trustee is going to depend on the severity of the fiduciary breaches and the harm caused to the trust and you, its beneficiaries, by the misconduct. Breach of fiduciary duty cases are very fact determinative, so you'd be best served to discuss your situation with an experienced trust litigation lawyer to learn about your options, including filing a petition for suspension, removal, breach of fiduciary duty, surcharge, or damages. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email, or schedule a free consultation online on our website, rmolawyers.com. Thanks for watching.